Okay, I think we can start. I got the message that we are now live. So good morning, everyone. I hope that everybody can see and can hear us. Welcome to the panel hosted by GESEL Attorneys at Law within ICC Make Climate Action Everyone's Business Forum. My name is Joanna Kisielińska-Garncarek. I am Managing Associate in GESEL Arbitration team and at the same time a member of GESEL for Climate Group. And I will have a pleasure to moderate the whole panel and the whole discussion today. In 1988, a scientist, James Hansen, provided something which is now considered as the first warning given to a mass audience about global warming. Namely, during the US congressional hearing, he told that he could declare with 99% confidence that a recent sharp rise in temperature was a result of human activity. And in an interview given recently to The Guardian, he said that all we have done is agree there is a problem. And today we will discuss one of possible reactions to this problem, namely the climate change litigation, which is gaining an incredible growth in importance in recent years. Globally, the number of climate change related cases has more than doubled since 2015. So now we may wonder who are the key players bringing these disputes into the courts, who are the other parties acting in defendants in these cases, and how courts have decided these cases so far. And finally, what about arbitration in climate cases? And today, these and other questions will be addressed by our speakers. At the end of our panel, we will have a short Q&A session. So if our audience has any questions in the meantime, please write them on the chat and I will pass them to the speakers. And now, starting with the keynote speech, let me introduce Eliseu Castineira. Eliseu is a great lawyer, founder of Castineira Law, participating in numerous international arbitration proceedings, both as counsel and as arbitrator. He handles various disputes with private entities, with states and state control entities in varied economic sectors, for example, construction and engineering, or energy and natural resources. His cases have involved parties from all continents and over 20 governing laws. He is also regularly recommended for his expertise in arbitration. And lastly, he developed a keen understanding of energy and climate change from, which might be surprising, also an engineering and scientific perspective. And this perspective will be presented to us today, also during the keynote speech. So, Eliseu, the floor is yours.
Thank you very much, Joanna, for the introduction. Many thanks to the GESEL for Climate team for inviting me to join this great panel. As Joanna said, I've been asked to include in my keynote remarks perspective on the current trends in climate arbitration. And before I do that, I want to set the stage by looking very briefly at what science tells us so far. Because it's very nice to be talking about climate change mitigation, but before you undertake a proper action, you need to know about the science, because otherwise anything you do is a shot in the dark. At the end of my presentation, I'm going to post 7 links that you may want to have a look at if you have time after the presentation, when you have time. Those 7 links are all scientific or engineering links, except for one, which is a reference to an article of the Financial Times. And I have included the summary for policymakers of the latest IPCC report on climate change that came out in August. The executive summary is 40 pages. The full report is over 4,000 pages long. But just have a look at the links if you have time. And with those links, I'm going to have sources to say 5 things about physical reality. First of all, in countries that could rely on fossil fuels, you have to understand that fossil fuels have been the most determinative factor that triggered economic growth, but not just economic growth. They have made it possible for modern political and social systems to develop. This is because you have to understand that fossil fuels are essentially food for machines, and machines are basically our energetic slaves that have made it possible for us human beings to multiply our physical force hundreds, thousands, sometimes millions of times over. Literally, and I mean that literally, without fossil fuels, none of us would be attending this webinar right now, and many of us would not be able to take any holidays. This is how much we owe to fossil fuels and why it is so difficult to get out of fossil fuels. And we all know, and this is my second point, that the downside of the fantastic efficiency of fossil fuels is that they release greenhouse gases into the atmosphere. And what we know also from the science, in particular, if we look at the IPCC reports, no matter what we do for the next 20 years, due to the very limited carbon budget that's available for us and our offspring, it will be very, very difficult to remain with the target of 1.5 degrees under the Paris Agreement. And it will be also very difficult even to remain within the 2 degrees Celsius increase that we're aiming for. It will be extremely, extremely difficult. The third point I want to make is that one has to bear in mind the issue of tipping points, which means that as of a certain point, a very small percentage of increase in temperature could trigger exponential consequences that may not be reversed. I'll just give you an example. There's permafrost is currently melting, which has the potential to release some old viruses and bacteria, but also methane. And there could be a feedback loop between methane that's released from permafrost and other greenhouse gases, and that could be quite exponential. To give you a more concrete example, if we reach 3 degrees, and 3 degrees is right now our most likely trend, it is by no means guaranteed that we could have any democratic regime because we'll have mass migration, the spread of diseases, famines, droughts, floods, war. So it would be very, very difficult to maintain political stability. At about 4 degrees, basically, living in the tropics would be deadly 1 day out of 2. And this is the fourth point I want to make. And taking into account the very little time frame we have to act, if we are really serious to mitigate climate change, betting that technology will save us, or that it will be enough, would be a very dangerous bet. And actually, the more you talk to scientists and engineers, the more you understand that innovation will not just be technological. Of course, it's needed, but it's not going to be enough. Innovation will be very largely social and political. And the last point I want to make on physical reality is that at some stage, no matter what we do, whether we choose to act to mitigate climate change or we just sit back and we keep going with business as usual, at some stage we will have to endure an energy diet, either willingly, because we really try to mitigate the effects of climate change and we just cut down on energy at some stage, or unwillingly because of the diminishing access in the long run to certain natural resources, and also what's called the diminishing energy returns on energy invested to obtain energy. So it is very likely that at some stage we'll go on the diet, even if we don't want to. Now that I have set the stage, I'm going to talk about what we called climate arbitration and make a few suggestions as to how we could improve the process to try to really mitigate the effects of climate change by the means of arbitration. First of all, is there anything as really climate arbitration? When you look at the publicly available record, so far, you must say that climate change as such has not been addressed expressly and directly by awards. Basically, if you look at all of the awards that have been published in relation to the Energy Charter Treaty that have been made public, some of them, about 20%, but no more, mention climate change or a convention on climate change, such as the UNFCCC, by way of background, but they never mention climate change or in the reasoning part of the arbitral awards. So the question is basically, why is not climate change directly or expressly dealt with in the reasoning part of the awards, which means that basically it doesn't play a direct part into the decision. I see three main reasons for this. The first reason is that basically commercial arbitration relates to business disputes, and investment arbitration, as conceived today, is largely focused on deciding whether investment should be protected in cases of changes in regulations. So it's a matter of focus. The second reason, which I think is very important, is the lack of direct involvement of the most active segments of civil society, NGOs or local communities in the arbitral process, because basically, unlike state court litigation, they usually don't have any standing to sue in arbitration. They're not parties to the arbitration clauses. They're not parties to the investment treaties. The last point is basically the lack of understanding of the basic science and the basic scientific points I've made earlier, not just by the lawyers, but by all participants in the process, i.e. businesses, and governments, and the level of education is, in that respect, notwithstanding what many people say, is still very low. So if you're not really aware of the importance of an issue, it's going to be difficult to raise that issue. However, this does not mean that arbitration does not deal with disputes that involve climate change issues. In fact, it's quite the opposite, because arbitration handles many disputes involving energy, mining, infrastructure, construction, engineering, transport. All of those obviously have a very important energy component and also therefore a climate change component. But even beyond those disputes, one must bear in mind that pretty much every type of business dispute is arbitrable, and that every business activity basically involves a climate change aspect, because, as I said before, every business at some stage involves a machine. And if you have a machine, that means that you have energy, and energy impacts both climate change and biodiversity. And when you're talking about energy, climate, biodiversity, all of those subjects are obviously closely related. The climate change component of disputes going to arbitration will only increase because with energy transition, we're going to be phasing out old industries like coal, or there will be investment in new technologies generating disputes. And all of this is going to be exacerbated by the rising energy constraints and the potential political volatility and changing regulatory environments. Now, and this is going to be my last point, I'm going to go quickly over a few suggestions to take into account climate change mitigation in the arbitral process. First suggestion, I think, is that we have to start treating the issue of climate change and biodiversity in systemic fashion like corruption. 70 years ago, if both parties did not have an interest in raising corruption in arbitration, basically it was considered that arbitrators did not have jurisdiction. Today, it's a very different mindset. Arbitrators have to see red flags. They have to raise the issue of corruption if they think they have a problem, that they can cancel the contract. So you need to put today the issue of climate change, especially in energy transition disputes, to treat it exactly the same way as corruption. It needs to be raised. I think that as of today, no award on energy transition should ever be rendered without an analysis of the climate change aspect. I even suggest to give it some thought as to whether it would be a breach of public policy or of the arbitrator's mandate if climate change was not dealt as an issue in an energy transition award. The second point is, I think we need to feel the public policy concepts that apply in investment treaties with science and scientific knowledge. And we need to be aware, I think, that awards may be set aside or not enforced on the ground of public policy if they interfere with the state's obligation to limit the effect of climate change, especially in those countries in which the states have already been condemned by their own state courts because they were not taking enough action to fight off the effects of climate change. And we'll speak about, Dennis, I think, about the Urgenda case in the Netherlands in that respect. Four, I think we need to make science and engineering an integrated part of the dispute resolution system by way of a standing body of experts or through experts appointed by the arbitral tribunal. I believe that for climate change science, it would be possibly a much more efficient system to have experts appointed by the arbitral tribunal rather than the parties themselves. Fifth point, I think in investment arbitration involving energy transition, we need to make a broader use of amicus curiae filed by NGOs that have a legitimate interest and force the arbitral tribunal and the parties to deal with the comments of NGOs for energy transition cases in investment arbitration. And the last point I want to make, because I'm at 14 minutes, I see, is that I think we need to have more often forums where we have a direct discussion between engineers, and engineers are the people who translate the science into action, economists, accountants, lawyers. I'll give you just an example. If we look at damages models, the way they're construed, they probably need to be revised in energy transition cases and in climate change issues in very dramatic fashion. For instance, so far, there's no accounting model that values the cost of a stable climate system, which is what we had and that enabled us to develop our economies and political systems, and natural resources. The cost of natural resources that nature gave us for free is actually not factored properly in the economic systems, the accounting systems, and the valuation of damages that we have in arbitration. So since I'm nearing 15 minutes, I'll just leave it there and I'll make a post right now of my sources, if I can, on the chat, so that everyone may have a look at it if they wish later on.
Sure. Thank you very much, Eliseo, for all remarks made during your keynote speech. I think that these remarks of scientific nature, the necessity to understand science in climate cases, were very inspiring, especially for all lawyers taking part in this panel, and also the suggestions when it comes to the role of arbitration in climate cases were very inspiring to me. I will have probably one question about amicus curiae, but I will leave it for the Q&A session. And if our audience has questions to Eliseo, this is a kind reminder that you should put them on chat.
Joanna, I'm going to send you by email the sources, because for some reason I cannot post them on the chat.
So okay, so if somebody is interested, we can also distribute it via organizers of the panel.
So I'll send you an email with the sources, and I'll leave the session now, and I'll see you for the Q&A. Thank you.
Thank you very much. Stay with us for the Q&A session. And now we will move to the discussion about major climate litigation, mainly in Europe, but also worldwide. So let me introduce our fantastic three speakers. You should be on the stage right now. Oh, great. I think I see everyone. So I will start the introduction with Sophie Marianac. Sophie is an expert in climate change litigation, in human rights and corporate management of climate risk. She leads Client Earth Climate Accountability Initiative, focusing on legal interventions in order to drive governments and companies towards acting in line with the Paris Agreement towards reducing the emissions. She's the lead lawyer in the groundbreaking Torres Strait climate case. It was the first climate case to be brought against the Australian government on human rights grounds. Our second panelist, Dennis van Berkel, he's legal counsel to the Argenda Foundation and the director of the Climate Litigation Network. If we hear Argenda, we all know that in 2015, Argenda Foundation won the first case ever in which a court concluded that the government has in fact legal duty to reduce emissions in order to prevent dangerous climate change. And the Argenda judgment triggered a wave of similar cases worldwide. This is why the Climate Litigation Network was created to respond to this wave. They are supporting other litigations along with Dennis, of course. And last but not least, Maja Fronczak, attorney at law, senior associate in arbitration and litigation team of GESEL. She is specializing in complex civil and commercial disputes. She's also a lead lawyer in the Poland's first citizen climate lawsuits developed jointly with the Client Earth Foundation this year. She frequently publishes about climate-related cases. And apart from being a lawyer, she also graduated from the Music University playing a saxophone. As you see, we have three fantastic experts in climate litigation involved in groundbreaking cases across Europe and worldwide. And I would like Dennis to open our discussion and address the first question to him. So firstly, I would like to ask, because Argenda inspired a lot of organizations and a lot of climate cases, but what were Argenda's inspirations while initiating this precedent-setting case? How old is your case started?
Thank you, Joanna. And let me start by saying that I'm very, very happy to be joining this conference and this panel in particular. I think there were more general inspirations with regards to places where lawyers have played a very important role in pushing large societal changes, which is the civil rights movement in the United States, in the equal rights movements that have played out in many different countries. Those are just a couple of examples. More concretely, there was, and these were all inspirations for a particular lawyer, Roger Cox, that wrote a book that he titled Revolution Justified, in which he set out one. And it is completely agree with Eliseo in his keynote speech. One, he set out the facts because that's the basis. And then he said, how can we use the facts in court to basically claim that the Dutch government is acting unlawfully with regards to its inhabitants because it is exposing its inhabitants to these massive dangers of climate change. And so the book was the impetus and the inspiration for Argenda then to also start the case together with this lawyer, Roger Cox, and other lawyers in 2013. Joanna, you're on mute.
Unmuted already. Dennis, and could you please tell us something more about legal framework of the case? Because I think this is very interesting for our audience. So what kind of legal provisions you relied upon while suing the Netherlands government, whether domestic provisions or more these provisions of international nature?
Yeah, and it's a very good question, and also important to understand the basis for this Dutch case, because it explains why this idea of such a lawsuit is so generally applicable around the world and in different legal jurisdictions. The Netherlands did not have a climate act, so there was no statutory provisions on the basis of which the government needed to act on the basis of national law. It did not have a national target. In fact, it had no climate policies whatsoever, except for implementing EU obligations, basically. It was doing very bad. The Netherlands had and still has an extremely low percentage, for instance, if you look at the renewables with regards to the total energy use. So there was not much to base it on with regards to statutory provisions. So what we claimed in the case is that it was an unlawful act based, basically a tort. So on the basis of the civil code, we said it was an unlawful act not to reduce the emissions to the level to which the government itself had said that it was necessary. And the government at the time had said that we need to limit emissions to 2 degrees. And in order to do so, science tells us that we need to limit it to 25 to 40% below 1990 levels by 2020. That was all recognized. That was science that was published by the IPCC. And we said two things. One, we claimed that this was violated the general duty of care under tort law. In other words, that it consisted of it formed a hazardous negligence on the side of the state, and two, that it was a violation of human rights, and that both of these both violations simultaneously or independently would be an unlawful act with regards to the people filing the case. The court of first instance found in our favor on the basis of the first concept, so this general open norm, this duty of care of hazardous negligence, and then the court of appeal, because the state appealed the case, found the basis in these human rights violations, more specifically Article 2 and Article 8 of the European Convention on Human Rights. It found that the state had positive obligations on the basis of those two articles, the right to life and the right to private life, to reduce the emissions from the Dutch territory to a level which would be consistent with preventing dangerous climate change, and then looked at science as sort of information, both science and international norms, such as the climate convention, etc., because these are obviously open norms. The right to life in itself doesn't say what a state needs to do, but it looked at all these international sources, the climate convention, statements by human rights bodies with regards to the impacts of climate change on human rights, to then come to a more concrete formulation of the rights or the obligations of the state with regards to the Dutch inhabitants. And that's how it came to the order. It ordered the state to reduce its emissions by 25% because it felt that was what is necessary to comply with its positive obligation.
So Dennis, I have one question to this question. So how did the court treat the IPCC reports? As the expert reports, or more like source of soft law, something like that?
Well, there was there were sources of soft law were used in many instances. The IPCC was not a soft law source, but it was a statement of undisputed scientific facts, and it was undisputed because it was not disputed by the state, by the Dutch state, which is also logical because the IPCC is an intergovernmental panel on climate change. In other words, the governments of the world actually participate in the IPCC and also approve the final reports of the IPCC. So the IPCC is not a statement of a small group of scientists. No, it's a statement of the entire consensus of not only the scientific community, but also of the states themselves and their scientific experts on what the state of the art of the science is. So there was no discussion on the science of the IPCC, and therefore the court could also took so much importance of the facts of the IPCC.
Okay, thank you. And the next question is quite crucial for me, bearing in mind the fact that our agenda judgment was given several years ago. What kind of influence it had on the climate policy in Netherlands? What are you observing right now in Netherlands?
Well, it really put the facts on the record. Before the agenda judgment, there were still people in Parliament, leaders of the biggest fractions in Parliament saying, well, we don't know whether humans are causing climate change. After the judgment, that really put the facts on the record. There were no more discussions. Climate change is a massive threat and we're not doing enough to address it. So it really changed the political dynamics. It really put a lot of pressure on both formulating short-term policies and long-term policies. So a climate act was adopted, coal-fired power was decided to be phased out. So those were the most immediate things. And then after that came the harder things, and those are the short-term measures. The state was a bit late with regards to also adopting the short-term measures to get the emissions below the 25% target in 2020, because it was anticipating that it would win an appeal. Once it lost an appeal, it also started to seriously look at possibilities to also speed up the short-term emission reductions. And that has also led to now in total a total package of around 10 billion euros with regards to investments in renewable energy, energy efficiency, and also closing of coal-fired power plants. And those coal-fired power plants were plants that were only opened in 2015 and 16. So those are very new plants. And what we do see with regards to this part, and that's what you could say, sort of the implementation of the judgment itself, is that we're seeing that specifically with regards to the closing of those coal-fired power plants and what is really necessary to implement the judgment, that arbitration is also playing a difficult role in this space, basically hampering the real implementation of the judgment, because on the basis of, and this is I'm perhaps broadening out, but I think it's extremely important also for this audience. I mentioned the phasing out of coal-fired power plants in 2030. That was a law, and that law has been challenged by Uniper and RWE, the owners of these brand new plants, which they promised would actually capture CO2 and put it under the ground, but they never did so. And they launched arbitration proceedings under the Energy Charter Treaty. And what we're now seeing is that those arbitration proceedings and the billion-euro claims that they have filed are really hampering closing the coal-fired power plants even earlier, which is what is really necessary in order to also implement the judgment. So the government promised to close an additional plant before 2020 and to reduce the capacity of the remaining plants to really keep it to the minimum, because that's what we need. But they're still negotiating this, and it's very clear that the reason why they haven't come to an agreement is because of this massive threat of another arbitration proceeding under the Energy Charter Treaty, and that it's really hampering more progress in Dutch climate policies right now. So in the Netherlands at the moment, specifically the Energy Charter Treaty and the threat of arbitration is playing a very worrisome influence over slowing down the progress in climate policies.
Thank you, Dennis, very much. It was extremely interesting to hear about the outset of the case and then about recent developments in Netherlands, especially in the context of Energy Charter Treaty. I think it's a hot topic in climate, let's say climate arbitration in this context in recent years. And now I would like to move to Maya, because the lawsuits against Polish government prepared together with Client Earth were undoubtedly inspired by Agenda case. So Maya, could you please give us an overview how the cases were composed in Polish legal system? What kind of legal concept did you use in comparison to Agenda case?
Okay, it is the fact that an Agenda case was indeed an inspiration for many citizens and organizations worldwide to join the movement of climate litigation cases. And we are an example of that. Our initiative brought together with Client Earth against the Polish state. And what Dennis have already mentioned, there is an issue of particularities of each legal system. That means that although we think that the Agenda ruling could and should be followed in other countries, there is also a question of adjustment to a certain given legal system. And what we decided to do in our case is to base our cases on the concept of personal rights. This is a concept of the Polish Civil Code. And personal rights are non-economic values commonly recognized in the society, which are very closely linked to the personality and dignity of natural person. So for this reason, in our cases, we instigated 5 different litigations. We represent 5 individuals, 5 citizens, to seek the protection of their respective personal rights. So our cases are not brought to protect the right of the general public. And the thing about the personal rights is that they do not constitute a closed catalog, but this catalog is open and it is designed so that it could follow the changes in society and evolve and encompass new personal rights. And to give you an example, when it comes to traditional personal rights, there are such rights as freedom, a right to health, freedom of conscience. But the new rights, which are now understood as well as personal rights, are, for instance, the issue of gender, right to be forgotten, or a cult of the memory of the deceased. And the personal rights that we seek protection in our cases, there are several personal rights, and some of them are traditional, let's say traditional personal rights, and some of them are new. And starting with traditional personal rights, we refer to right to health, respect for the place of residence and psychological peace, and right to privacy and respect for family life. And when it comes to a new right that we think also merits legal protection and should be considered as personal right, this is a right to the enjoyment of environmental values, which right includes the right to live in stable and secure climatic conditions. And what is important as well and about personal rights is that this concept should not be confused with human rights. Although human rights are obviously respected and recognized within the Polish system, they cannot be directly protected in civil litigation based on the civil law. And there are, however, human rights that are at the same time personal rights. For instance, right to life, right to health or freedom. But there are also human rights which are not considered to be personal rights. For instance, political rights or such rights as right to fair trial, since they are not inseparable from the human personality. But however, we do refer to human rights in our cases, but we did it in order to demonstrate that the state's acts and omissions are illegal. So this is similarly as in our agenda case, we also refer to the rights recognized under the European Convention on Human Rights, and that is right to life and right to respect for private and family life. And we want to demonstrate that the premise of illegality is indeed met in our case. And apart from European Convention on Human Rights, we also refer to the Paris Agreement. And in order to demonstrate that the states, that the national emissions of greenhouse gases, the excessive amount of those emissions, is contrary to the goals, to the temperature goals of the Paris Agreement. And in our case, we do not seek any pecuniary claims. We don't seek for any damages, but similarly to our agenda case, we also want the state to be obliged to reduce its greenhouse gas emissions.
Okay, and as you mentioned in these Polish cases, it was indispensable to prove that excessive emissions had an impact on situation of these 5 particular persons. So could you please describe some example of stories of these persons taking action against the Polish government?
Yes, of course. Since, as I mentioned, we represent 5 individuals, we are demonstrating in our cases that the consequences of climate change dramatically interfere with their daily lives. And to give you an example, one of the persons that we represent, this is a man who lives, who has a house in the middle of the forest. And that was his choice, to live in a place surrounded by nature. He wanted to lead his family life there and raise his grandchildren. And due to the setting of his place of residence, he's significantly vulnerable to all weather phenomena that are the consequences of climate change. And what he experienced is, for instance, the fact that water reservoirs and lakes are drying up. The forests are drying up. He's facing the risk of water scarcity. There are a lot of heat waves in the summer period, which force him to stay at home and actually prevent him from enjoying the natural environment surrounding his house. There are wildfires in the forest that surround his house, and actually those wildfires are approaching his property each time. As well, he sees tornadoes and severe storms. And what he also observes is the spread of ticks in the forests that carry dangerous diseases such as borreliosis. And all those events, those weather events, put together, put his life and well-being in danger. And according to scientific prognosis, all those events will intensify in the future. So at this very moment, his rights are already infringed, but he is also at risk of further violation of his personal rights due to climate change.
Thank you, Maya, for the description of this story. And I have the last question, probably pertaining to both Polish cases and agenda case. Because when we think about courts forcing governments to reduce excessive emissions, the question which comes to my mind is rule of separation of powers. And do such climate lawsuits violate somehow this let's say, fundamental rule, so the separation of powers?
Well, it is a problem which is tackled in these types of cases, I mean, climate cases brought against the government. And in our opinion, our claims do not interfere with the powers of legislative and executive branch. And this issue was also tackled in our agenda case and explained by the Dutch Supreme Court. And the reasoning standing behind this conclusion is that there are 2 things that should be distinguished. First is the issue of political decision-making process, which indeed exceeds the powers of the court. However, when there is a legal issue at stake, for instance, when there is a question of infringement of law, and in particular violation of human rights, the existence of these questions, these legal questions, allow the courts to decide the case, since courts are competent to deal with legal questions and legal matters. And since contributing to climate change does interfere, for instance, with human rights, the courts are competent to hear and decide such cases. And we are of the opinion that this concept should be applied and followed in every case brought against the government.
Thank you very much, Maya. So far, we have discussed with Denis and Maya the actions taken against states. However, in the course of this panel, we would like to give also another perspective, and this task will be handled by Sophie. Sophie will give us an overview of climate cases initiated against private entities worldwide, and she will shed some light on various kinds of such cases and also different legal bases thereof. So Sophie, the floor is yours now. Sophie, I think we can't hear you, or it's just me. I think that now it might be better.
Yes, you can hear me now?
Yes, it's perfect, yes.
Okay, great. I can take these off. Thank you so much, Joanna. It's lovely to be with you today, and thank you to the previous speakers for those fascinating discussions. I will just briefly give a rundown of 3 different types of climate change case that we are seeing emerge against private entities. So, of course, around the world, there has been a huge wave of climate litigation, and it's not actually the first. So in the 2000s, there were several cases, many and the majority of them in the United States, brought by climate vulnerable communities against large oil companies, including ExxonMobil, also against utilities, so electricity companies as well. Those cases, at least in the US, were unsuccessful. However, we're seeing a second wave of claims against private companies, and some of those are having some incredible success. So in the US, there are a series of cases that have been brought by both cities and local governments against a group of companies called the carbon majors. The carbon majors were identified in a study by Richard Heady several years ago, and they are the largest producers of fossil fuels in the world, and they include all of the major oil companies and oil, coal, and gas companies. In the US, these cases, which were filed in the previous 5 years, are often in preliminary disputes in relation to whether those claims should be heard in state court or in federal court. However, once they're decided on the merits, there could potentially be significant consequences for the oil and gas industry. And that's because those claims are seeking damages. So they're seeking part of the costs of adaptation to climate impacts on behalf of cities and local governments and their citizens. So those claims in the US have a potential to be a real game changer, and that's because of the financial compensation that is being sought by the claimants. In Europe, while in the US those claims remain to be resolved, in Europe we've seen very recently, earlier this year in April, probably the most significant breakthrough in climate change litigation against private companies to date. And that is a case also brought by Roger Cox and his team in the Netherlands against Shell, Royal Dutch Shell. Now, this claim was quite similar to the US tort claims. However, it did not seek damages. It sought injunctive relief against Royal Dutch Shell, arguing that under the Dutch Civil Code, the company was obliged to reduce its emissions in line with the goals of the Paris Agreement. That is, in a way in which the company would reduce its emissions by a sufficient quantity so as to allow the world to meet the temperature goal of Paris. And that was a far more significant reduction trajectory than the company had proposed to its shareholders, in fact, just the week before the decision. So that case is fascinating for many reasons, not least because it also brings in private entities' human rights obligations under the United Nations Guiding Principles on Business and Human Rights. So the Dutch court found that private companies also had human rights obligations to reduce their emissions. And that claim, I think we will see replicated in courts around the world in the coming years. There has been some mixed success in the tort claims. So 2 weeks ago now, a court in New Zealand rejected a very similar tort claim against some smaller private companies in New Zealand on a very similar basis to the Shell case. That decision is being appealed. However, it's clear that the final outcome and the way in which these tort claims against private companies play out is yet to be resolved, and we may see uneven progress in different regions for several years as these claims make their way through the courts and up to appeals courts in each jurisdiction. So it's certainly an incredibly exciting area to watch. However, there are many other ways in which private entities are being challenged on their climate change related behavior. Specifically, there are many claims related presently to reporting and disclosure. And that's because private entities are required under the laws governing their corporate reporting to disclose the impacts of climate change on their business. Now, when they do that, sometimes companies may provide information to the market that is false, misleading, and deceptive. There have been several claims against companies on this basis in the past few years, so-called greenwashing cases. Our organisation, Client Earth, for example, brought a complaint against BP under the OECD guidelines for multinational enterprises 2 years ago, arguing that BP's advertising was misleading consumers in the UK as to the way that it was transitioning its business away from fossil fuels. The company then removed that advertising campaign from public view. However, there have been a series of other complaints under various advertising law and regulation, including successfully very recently in the Netherlands as well, against Shell in relation to its claims to be offsetting its emissions with tree planting and other activities. There's also a really interesting claim in Australia against Santos under the Australian consumer law for its claims about the environmental capacity and potential of fossil gas. And finally, so the greenwashing claims is a particularly hot area at the moment, I'd say. Huge amount of interest in that. And that's just because we're seeing a lot of pressure placed on private entities over this issue. And many of those entities are very keen to come out with statements that that encourage the public to believe that they are part of the solution, that they need to continue operating, and that they need the protection of policymakers and governments. So there's a lot of strategic public relations from industry over these issues at the moment, and therefore there's a high risk of misleading claims and greenwashing. The final category of cases are those that are being brought by shareholders. Excuse me. And I'll just mention one case that Client Earth was involved in. Excuse me. We brought a case against Enea and Energa, two Polish entities, and that was our Polish foundation. But that foundation, that claim was brought as a shareholder, arguing that the company's decisions to invest in a coal-fired power station were contrary to the best interests of its shareholders, but not for environmental reasons, for financial reasons. And we argued that because this project, this coal-fired power plant, was actually predicted to lose the company money over its lifetime because of the increasing cost of carbon through the emissions trading scheme, that excuse me, that this we argued that the plant would be contrary to the best interests of the shareholders, and we were successful in the Polish courts. And when that decision was made, the share price actually increased, showing that in that case, the interests of shareholders and of the environment were aligned. Thanks very much, Joanna.
Thank you very much, Sophie. I think that from your speech, we can see that there is a whole variety of climate cases already initiated or to be initiated against private entities, that we should follow these cases both in Europe and worldwide. Many thanks for your observations in this regard. And now we have several minutes left, so I think that we can switch to the Q&A session. We have our keynote speaker already on the stage. I have two questions from our audience in the chat, so I will address the first one. What is the point of suing individual government entities, given that each of them has limited impact on climate change and did not cause the climate problem, so the global warming by itself on its own? And maybe I will start with Maya and then pass this question also to other speakers.
Okay, thank you for this question. This is a very important one, and it is also actually an argument which is put as part of the line of defense of the entities or governments which are sued before the courts, that they on their own did not cause the problem of global warming, and also that their alone acts cannot resolve the problem of the climate change. However, we think that this is justified and reasonable to put forward such claims for at least two reasons. And first is connected to the science knowledge, since we know now, and the latest sixth report of the IPCC also confirms that every emission counts and has its impact on the increase of the degree of global warming. And the effects of global warming are not the same, but they vary depending on the degree of the temperature increase. And also Eliseo has mentioned today those differences, and the living conditions of the world, which is 2 degrees warmer, are different to those consequences of the world 4 degrees warmer. So every emission and every reduction counts. So it is reasonable to bring an action against individuals. And also there is a legal justification for that, because if we accept that since this is a global problem and no single entity is causing this problem, that would mean that we accept that actually no one bears any responsibility for global warming and climate change. And what we want to show, and the message that we want to send, is that everyone should be responsible for its own part of contributing to global warming and climate change. And those entities, since they are not capable to stop the global problem, they are indeed capable to reduce their own emissions. And this is something that we think they should be held liable for.
Dennis, would you like to add something in the context of agenda case?
Yeah, very happy to do so. I mean, the underlying presumption behind the question is that it would be better to deal with this at the international stage. And that's, of course, entirely true if that were to happen. But we've been doing that for 30 years and it's not happening. So we can say, okay, international way is not happening, and we'll just throw up everything in the air and we'll just have the climate crisis crush over us. Or we say, what do we do with the imperfect legal tools, because they are imperfect, with the imperfect legal tools that we have at hand, and how can we at least contribute to fighting this climate crisis? And there are, as Marja outlined, very good reasons why even though there are multiple entities causing the problem, doesn't mean that you by yourself have no responsibility. If you are trashing a car with 10 people, it doesn't mean that none of them has any responsibility for being part of trashing that car. It makes total legal sense that if you're contributing part of a problem, you are responsible for that part, and you should take that responsibility, and you can be held to account if you're not doing so.
Yeah. If I may, I'll add a very brief comment. I believe in the virtue of imitation. Imitation is characteristic of a human species. Basically, it's the way fashion works. The way you learn how to walk is that how to talk. It's like you heard your parents and you imitated your parents. So if you have decisions that come up like Agenda, like Grand Sainte or Affaire du siècle in France, like what happens in Poland, those decisions come out against governments, and it starts imitation around the world, and you may change the system. Like when there was the New Deal, for 40 years we lived in the West under the New Deal, Keynesianism, ideology, that type of economics. Then there was Reagan and Thatcher with new neoliberalism, whatever you may call it, for 40 years. And now it's going to be a different era, possibly. So imitation is very important. So if something big happens somewhere, I think people will imitate somewhere else.
Thank you very much. Sophie, I think that I have two questions directed to you. So maybe started with the last one. What happens when interests of shareholders are contrary to fiduciary duty of company? I mean, shouldn't it be easier to bring together that environmental shareholder alignment that happened in that case you shared? You should confront the board right to live up its duty. This is the end of the question. It is visible on the chat if it's easier for you.
Yeah, so of course in the Ostroleka case, it was quite easy to demonstrate that environmental interests were aligned with economic interest, and that's because we had very clear report from the Carbon Tracker initiative finding that, and other experts in Poland finding that the particular project in issue would lose the company money, and in fact the company itself and independent financial analysts agreed that the project would lose the company money. However, the concept of the best interests of the company, I think, remains to be explored, and companies now acknowledge that climate change will have significant negative financial impact on them, both presently and worsening into the future. So we know that increased costs associated with extreme weather, disruption to supply chains, loss of productive time and capacity. These are all really significant challenges that companies all over the world are dealing with presently. And so the concept of fiduciary duty, I think, is yet to be fully tested in many jurisdictions. Because directors, we at Client Earth, we have conducted this analysis, and we find that overall directors need to be thinking about climate risk. They need to be actively managing it. They cannot put their heads in the sand and pretend that this is a so-called ESG issue. This is a materially financial issue and becoming even more important for corporate governance every day, particularly after the announcements this week at COP. So it is really, I think, another area of law in this fascinating field to really watch.
Thank you very much. The next question is addressing another hot topic in recent months, namely Fit for 55 package. And the question is that, do you think that this package, Fit for 55, is compatible with the temperature goals of Paris Agreement? And is it enough for the European Union? I see that Dennis would like to say something, so please.
Well, I think often the most trustworthy statement with regards to whether an effort is enough or not is to listen to the person themselves proposing the statement. And the EU itself is saying that this is not enough. No? So, and that's why also it's an at least 55% reduction target. When the reduction target was first proposed, there was agreement that it was not enough. Actually, the European Parliament said, if we just do what the global average is of what needs to be done, and we as Europe actually need to do more than the global average, it should be at least 65% reduction, not 55% reduction. You can also see this, for instance, in a very important judgment by the German Constitutional Court, where the German Constitutional Court looks at a 55% reduction target for Germany, and it says, if we follow that reduction target, the carbon budget for Germany is almost entirely depleted. There will be no more emission space left after 2030, and it would mean that we would basically have to reduce emissions within a year. I mean, we should all be leaving our houses, camp outside, and chew on a stick in order to get to that. And that's actually a violation of the fundamental rights of German citizens. Now, I'm using this case as an example of a court that's looking at the facts, not at political convenience or reality or whatever, looking at the fact, saying this is not enough, you have to do better, based on fundamental rights. And I think that's also the answer to the Fit for 55 target. It's the European Union itself says that this is below what can be perceived as the absolute minimum, which would be the average of what we need in the globe. So it's simply not enough. We need to do more.
And if I may say, in French, we have a saying that says, there is no love, there is only proof of love. So even assuming that it would be enough, the main problem is that people have been doing a lot of talking, but there's not very much walking the talk.
Thank you very much. Next question from our audience. I think the last one for now, because there will be just one more from me, is about the assessment about the solution of ad hoc mediation for settlement for the greenwashing cases according to Article 24 of the Paris Agreement in connection with the Convention on Settlement of Disputes. As Sophie tackled the issue of greenwashing, maybe you would like to respond.
I can't actually see that question, Joanna, but
it's from 1257 from Samantha on the chat.
Okay. In any event, I think that the dispute resolution mechanism under the Paris Agreement applies to states, and I think that mechanism has not necessarily yet been fully activated. I think as part of the COP rulebook, we should hopefully see more information about how the Compliance Committee will operate and how the Compliance Committee will hopefully assess states' obligations to provide NDCs, that is, emissions reduction targets in their nationally determined contribution that represent, as required by Paris, their highest possible ambition. I think that's the crucial test in international law. In terms of greenwashing by companies and by states, I think national cases can hold states to account, those that Dennis and Maya have spoken about, but also the Paris Agreement does have this dispute resolution and the mechanism, and I think that will hopefully play a really important role in identifying what the legal tests are for states' contributions.
Thank you very much. And I have one question about the concept which was mentioned during our keynote speech, the concept of amicus curiae. Because Eliseo, you mentioned it, that's one of the solutions to be engaged in climate arbitration. And I would like to ask you about the examples of such actions, and maybe I will address this question also to other speakers, whether you were considering filing an amicus curiae in other cases, and could you share your views on the importance of this institution on the side, mainly on the NGOs?
I think on my side, I mean, so far as I said, climate change has not been directly expressly dealt with, but only indirectly. But there's been amicus curiae in environmental arbitration cases. I think it's an important mechanism because, as I said before, there's a lack of knowledge of basic scientific knowledge of governments and business people because they don't take the trainings. If you're directly affected by a climate change event as an indigenous community or an NGO that specializes in the area, chances are you may develop that kind of scientific and engineering knowledge that I think is very relevant. So I think it would be an important part of investment arbitration to allow in energy transition cases NGOs to file amicus curiae. That's possible. Maybe there should be a threshold in terms of a certain legitimacy test that the particular organization is active in a particular area. Maybe there could be a filter. I don't know, but I definitely think that they should be able to intervene, and that arbitral tribunals and parties should address the comments contained in the amicus curiae submission, and I think it is an important part of bringing the actors up to speed, in my view, in investment arbitration. Even if I'm not sure that so many of my colleagues would share that opinion, it is my position.
Thank you. And Dennis, would you like to add something from the perspective of the foundation?
Yes, no, I'm heartened by the fact that what Eliseo says, that this is important, that an NGO should be given this stage. From the side of the NGOs, I mean, thus far, it is extremely difficult for an NGO to engage with this field because we have basically there's no procedures, no right, no nothing. There's absolutely nothing that provides you with sort of tools for you to bring the arguments to the court that we find are incredibly important, and very concretely, that is in this case of RWE and Uniper. We believe that any potential award to these two companies will hamper the human rights obligations of the Dutch state towards its residents with regards to the impacts of climate change, as were determined by the Dutch Supreme Court. So we see a massive problem with regards to these total separate legal spheres, where we have standing and rights and whatever under our national and international spheres. We have none under the arbitration sphere. So we are also quite, we don't really like it that much. You won't be surprised by the fact that we are very critical of the whole arbitration sphere. And thus far, our only solution that we have seen is to ask for politicians to just get out of the Energy Charter Treaty, simply because we see that this, at the moment, it's all bad. There's nothing positive in the whole sphere. And if people in the arbitration sphere thinks that it can actually contribute something, they need to start acting to help it be able to contribute something positively, because from where we are standing currently, it's all bad and we just need to get out. So that's a call to people that are looking at, active in the arbitration field and think that it is important that arbitration plays a positive role. Things will need to start moving in the arbitration field quickly. Otherwise, it will, our calls to get out will just increase.
Many thanks. I think that we have already run out of time. So we probably do not have time for more questions from the audience. I would like to thank all of the speakers taking part in today's panel. I have an impression that we managed to show that law can be a very useful tool in fighting against climate change, with all pros and cons in different configurations of these climate cases. Thank you for that, and big thank you to our audience for your presence, for questions, for discussion on chat. Goodbye and have a great day. Thank you very much on behalf of GESO for Climate.
Thanks, everyone.
Thank you.
Thank you. Bye.